So Commissioner, Mr. Sutherland, I will begin the meeting with some brief comments that the way I do in every single meeting. And we will then, I will ask for confirmation of the minutes, and that altogether usually takes about 5 minutes, and then I'll introduce you. Hi there, Paul. Welcome.
Hello.
Hi there, April. Welcome.
Good evening. How are you, Sarah?
Doing well. How about you?
I am doing well. I'm trying to figure out my lighting because it's can you all see me okay?
Yes.
Okay, fantastic. Good to see you, Lisa. Hello, Paul.
Hello.
Welcome, Joe.
Good evening.
I'm glad you're here. All right, with the arrival of Commissioner Fain, we have a quorum. So good evening. I would like to call this meeting to order. I'm Sarah Augustine, the chair of the Washington State Redistricting Commission. To introduce the topics for discussion and action this evening, I will reiterate our mandate. The mandate of the commission set out in Washington State Redistricting Act is to accomplish state legislative and congressional redistricting in accordance with the Washington State Constitution. The bipartisan commission was created to listen to the public every 10 years so that districts would be drawn by statute and with public input. Each commissioner was appointed to this commission. The 4 voting commissioners were appointed by the Democratic caucus in the House, the Republican caucus in the House, the Republican caucus in the Senate, or the Democratic caucus in the Senate. I was appointed by the 4 voting commissioners. As chair of the commission, I will articulate and manage the commissioners' process. In my role as chair, I will ensure that the process is as participatory, fair, and equitable as is possible. The 4 voting commissioners have power and responsibility to vote, ultimately creating and adopting a redistricting plan. Voting commissioners will make decisions that will create maps to best represent the interests of all Washingtonians. Those of you from the public joining us today, welcome. It is my goal to engage communities across Washington as fully as I can and to hear and address your concerns and requests. Throughout our tenure as commissioners, we will hear public comments that are important, ideas, requests, and injustices that may fall outside our ability to effectively respond. There are issues you may bring forward in your public comments that we may not be able to address. We can listen to you and be sure to capture your thoughts, questions, and requests. I will do my best to synthesize these, and we will respond to them as we are able. We will certainly deliberate on issues where we do have jurisdiction. Where we don't, I will do my best to refer you to those who may be able to respond more effectively. I would now like to review our purpose and values. Together as a commission, we've agreed to the following values and mission: to provide an open, transparent, credible process that is grounded in statute and where all voices are welcome and there is access for everyone. To conduct ourselves with transparency, respect, and civility, where commissioners will participate and negotiate in good faith, and to meet the deadline outlined by law and to produce the best possible maps. I would now like to call roll Commissioner Paul Graves, Commissioner Joe Fain,
Present.
Commissioner April Sims,
Present.
and Commissioner Brady Walkinshaw is traveling tonight and cannot join us. Before we begin our program, I would like to call for the approval of meeting minutes for the meeting held on June 7, 2021.
So moved.
Great. Second?
Second.
All in favor?
Aye.
Aye.
None opposed. The motion passes. Commissioners and members of the public, the Washington State Redistricting Commission is committed to keeping our constitutional and statutory commitments. In this spirit, we have committed to educating the Commission about the Federal Voting Rights Act before the Commission begins the process of drawing maps. I would now like to introduce Brian J. Sutherland, who has graciously agreed to speak with us this evening from the Attorney General's office. Mr. Sutherland is an experienced trial and appellate civil rights lawyer, serving as the Assistant Attorney General in the Civil Rights Division of the Washington State Attorney General's Office. He is a 2006 summa cum laude graduate of the Seattle University School of Law. He has worked for the ACLU Voting Rights Project in Atlanta, Georgia, the U.S. Equal Employment Opportunity Commission in Miami, Florida, and as a partner in private practice. In these roles, Mr. Sutherland has represented numerous individuals in constitutional civil rights cases and in cases brought under Voting Rights Act of 1965, Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, the Americans with Disabilities Act, and the Family and Medical Leave Act. He has also taken appeals to the Georgia Supreme Court, the 11th Circuit Court of Appeals, and the United States Supreme Court. Welcome, Mr. Sutherland.
Thank you very much. Good evening.
Good evening.
Okay. Well, I just want to say thank you for having me, first of all, and also thank you to all the commissioners and everyone who's involved in this important work. I have to say, as an attorney who has practiced voting rights law before, I'm sort of thrilled to be a part of this process by just being able to share information with you, but also as a voter and a citizen, just very grateful to be able to, share this information with you and be even a small part of this very important process. So thank you very much. What I want to do tonight is just present to you some information about vote dilution as it is prohibited by the Federal Voting Rights Act of 1965, and provide you with some information about that that will allow you to sort of dig deeper into that as appropriate in the course of your process. So what I want to talk about is providing you, I'm going to provide you with sort of the sources of law that relate to this, talk in a little bit more detail about how vote dilution is proved, and then raise some considerations for you to take with you. So with that, let's get started. Next slide, please. Okay, and the next one. Okay, the major statutory provision at issue is Section 2 of the Voting Rights Act of 1965. As you can see from this slide here, there's a lot of language and text here, but I've bolded for you in subsection B the sort of major important part as it relates to vote dilution. And subsection B provides that a violation of the Voting Rights Act is established if, based on the totality of circumstances, members of a protected class have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. And so what we're going to be talking about this evening is what that means in the context of elections. What does it mean when an election system is designed or operates in such a way that members of a protected class have less opportunity than others to elect candidates of their choice? Next slide, please. Other sources of law bearing on redistricting and vote dilution, however, include the Constitution. So the 14th Amendment's Equal Protection Clause, which requires that or prohibits states from denying equal protection of the laws to any person, and the 15th Amendment, which prohibits vote denial of the right to vote or abridgment of the right to vote by any state on the basis of race, color, or previous condition of servitude. Both prohibit discrimination in voting. Now, claims for vote dilution under the Constitution are not as common as claims under Section 2 of the Voting Rights Act, probably because the Constitution requires proof that discrimination was the intent of those who designed the election system or practice at issue. But constitutional considerations do arise in redistricting because racial gerrymanders are unconstitutional, and we're going to talk more about that as well. Next slide, please. So, Section 2 of the Voting Rights Act was explained or sort of given its most helpful initial explanation in the case of Thornburg versus Jingles, a Supreme Court case from 1985. And the court held that the essence of a Section 2 claim is that a certain electoral law, practice, or structure interacts with social and historical conditions to cause an inequality in the opportunities enjoyed by Black and white voters to elect their preferred representatives. So what does this mean really? And we're going to talk, and I'm going to give some explanations and some illustrations to try to operationalize this definition. But what are we talking about? A certain law or practice. What we're talking about there is a situation where a majority of the votes in a single member district determines the winner of an election. And that fact combined with how the district lines are drawn in a given jurisdiction. So that's the electoral law, practice, or structure that we're talking about. What about the social and historical conditions? Well, the social and historical conditions are the situation arising from the fact that people of color have been discriminated against in our society. Housing may be segregated such that persons of color live in a certain area within the political subdivision at issue, and or other factors, and also that voting is racially polarized, meaning that voters in different racial groups tend to vote for particular candidates, and that who they vote for or the candidates they support are different from voters in other racial groups or ethnic groups. So it's the combination of the way the electoral district or structure or practice is set up with the circumstances of discrimination and the effects thereof in a jurisdiction, which combined together may cause vote dilution. Next slide, please. So as I mentioned, Thornburg versus Jingles is the landmark case in this area that set forth the framework for proving vote dilution under Section 2 of the Voting Rights Act. And this includes the Jingles preconditions, which we're going to talk about, the Senate report factors, and also how courts should weigh the totality of the circumstances and evidence of both of these things. Now, in voting rights practice, there are a number of different cases that sort of go deeper and refine some of the major issues. We're not going to talk about all of that because there's a lot of law there, but we will talk about some of the major important decisions that sort of explain and set some bright lines on some of the major factors. Next slide, please. Okay, so I know this illustration here is too small to read, but I mainly provided it so that I can give you just a visual representation of what the analysis of vote dilution looks like in a court case. We're going to unpack each of these bubbles here as we go on, but I wanted to show you that the sort of first important showing that a plaintiff or group of plaintiffs in a Voting Rights Act vote dilution case must show is the Jingles preconditions. And it's 3 different elements that have to be shown, or else a vote dilution claim cannot continue and cannot be successful. Once a plaintiff or group of plaintiffs shows those preconditions, they may introduce additional evidence to support the Jingles preconditions, which come from a report that was issued by the United States Senate. And for that reason, these different factors are called the Senate report factors. With that evidence introduced, in addition to the evidence of the Jingles preconditions, the court will engage in the totality of the circumstances analysis to determine whether the election system at issue dilutes minority voting strength in violation of the Voting Rights Act. Next slide. The Jingles preconditions. The first precondition is what's referred to as compactness. And this means that the minority group is large and geographically compact enough that it can constitute a majority in a hypothetical district. So depending upon the different districts at issue in the election system at issue, where the minority group is located and whether that group is large enough and can be, whether it's even possible that that group could be a majority if the district lines were redrawn. That's the first precondition. The second and third preconditions are together racially polarized voting. The second is that the minority group is politically cohesive, meaning that that group votes together or tends to vote together in support of the same candidates across elections. And the third precondition, that the majority votes sufficiently as a block for other candidates, so as usually, in the absence of special circumstances, to defeat the minority's preferred candidate. Next slide. So the Jingles district must be, it must be possible to draw a Jingles district in order for a vote dilution claim to succeed. The minority population has to be large enough and geographically compact enough that it could form a majority in a possible or hypothetical district. And the Supreme Court explained that this is necessary to show vote dilution because otherwise it could be that the dispersal of the minority community throughout a geographic area is responsible for their electoral losses. There is no precise rule for compactness, but it must take into account traditional redistricting principles such as maintaining communities of interest, traditional boundaries, population equality, contiguity, respect for political subdivisions, incumbency protection, and the preservation of pre-existing majority-minority districts. Next slide. Jingles districts are, or I should say the possibility of drawing a Jingles district is proved by using accepted data sources to identify voters where they are and determine whether district lines could be drawn differently. Demographers who do redistricting analysis use accepted sources like the American Community Survey from the Census Bureau, voter registration by race in states that keep that information, and in some cases, surname analysis, where the surnames of registered voters in the district yield helpful information about the race or ethnicity of those voters. Demographics at the precinct level must often be estimated, so experts can disagree about whether minority voters actually constitute a majority in a proposed district. And demographers use specialized software to draw maps and to propose redistricting plans and to manipulate the data from the sources that I mentioned. Next slide. Okay, racially polarized voting. Racially polarized voting, as I mentioned, is the term given to both the second and third Jingles preconditions. And essentially what we're talking about here is statistical evidence that demonstrates the relationship between race or ethnicity in a given area, usually a precinct, and the candidates that have run for election in that district. In a Section 2 vote dilution case, the courts look to whether there is a minority preferred candidate, and racial polarization experts use accepted methodologies to analyze whether or not the percentage or concentration of minority voters in a particular area moves up or moves down in respect to the votes cast for a minority preferred candidate. Plotting all of this information into software and performing statistical analyses can yield that result or the conclusion of what the relationship is between race and voting preferences. Where voting is polarized along racial lines, that is, voters from one ethnic group or racial group tend to vote for one candidate, and voters from another group vote for the other candidate, and this is consistent, that is what's referred to as racially polarized voting. Next slide, please. So the analysis of racially polarized voting requires experts who do understand the statistical methodologies that are accepted by the courts and understood to yield reliable estimates of the relationship between race or ethnicity and voting preferences. These analyses include correlations, homogeneous precinct analyses, ecological regression analyses, and the ecological inference analysis. And as I mentioned, the analysis involves analyzing the data from each precinct, including official election returns, and the demographic data for each of those same precincts, and performing these analyses. But racially polarized voting may also be evidenced by the testimony of individuals involved in elections, such as candidates, campaign staff, community organizations, and those who have been engaged in the elections in the in the district or the area that's being looked at. Next slide, please. Okay, I'm hoping these illustrations will be helpful in terms of trying to kind of apply some of these principles and really visualize them. So types of vote dilution. There's a handful of different ways in which votes can be diluted and that have some names. The first is stacking. And if you look at this representation here of a jurisdiction that has 5 districts, 1, 2, 3, 4, 5, and the orange line that represents a new District 4 being drawn at the bottom middle of the jurisdiction, you can see that whereas the previous District 4 with the black outline seems to have perhaps maybe roughly equal proportion of minority voters and majority voters, the new District 4 has a lot more majority voters relative to the number of minority voters. And so if it was a close call in District 4 before redistricting, this new District 4, if there's racially polarized voting, we'll probably see minority voters in this district having a more difficult time electing a candidate of their preference. And so we say that in this circumstance, the minority population has been stacked with a larger majority population. Next slide, please. Another type of vote dilution is packing. So over-concentrating minority voters in one district such that they cannot form an effective majority in any other districts. So with this illustration, you can see in the same jurisdiction, 5 districts, and there's the same minority community in the central part of the district. And you can see that the lines are drawn such that most of the minority voters are all within District 3. Well, the minority voters may be a majority in District 3. And so District 3 could be a Jingles district if there were no district at all. And this was an at-large system that was maybe going to be converted to a district-based system. But as it is with District 3 existing here with this large number of minority voters, and there being hardly any minority voters in any other district, the chance and likelihood is that the minority voters are being packed into District 3 in a way that reduces their electoral strength in any other district. And so that's packing. Next slide. Now there's also cracking. So here in this picture of the jurisdiction, we have the same minority community in the central part of the jurisdiction. But we have the district lines drawn so that in districts 1, 2, 3, 4, and 5, each one of them has an appreciable number of minority voters, but they remain a minority in each one of the 5 districts. So this is a situation in which minority voters, if the voting is racially polarized and the other factors necessary for a vote dilution claim to succeed are present, they will not be able to elect a candidate of choice in any one of the 5. Next slide. So I mentioned earlier we would talk a little bit about constitutional considerations, and this is racial gerrymanders. So redistricting legislation that is geared towards maximizing minority voting strength may be a violation of the Equal Protection Clause of the Constitution if it is so bizarre on its face that it is unexplainable on grounds other than race. And so redistricting legislation which meets that standard is will be subject to close scrutiny by the courts, the same as other laws which classify citizens by race. And so this was recognized in a series of cases in the 1990s at the Supreme Court, the first being Shaw versus Reno. And in Miller versus Johnson in 1995, the Supreme Court explained a bit more what racial gerrymandering under the 14th Amendment is. It's an analytically distinct type of voting rights claim. It's not vote dilution, but it's related to redistricting. It's also not the shape of the district that has to be bizarre in order for a racial gerrymandering claim to exist. And that's not required for voters who are challenging a redistricting plan to prevail on such a claim. Rather, it is what they must show is that race was the predominant motivating factor in drawing a district. Now, the question or the argument has been raised in some cases. Well, what if a redistricting plan is undertaken in order to avoid a violation of Section 2 of the Voting Rights Act or other voting rights law? And there is not the clearest answer in the case law regarding this. But what the Supreme Court has said is that there must be at least a strong basis in evidence that it's or that the jurisdiction has good reasons to believe that using race as a classification in the redistricting process is necessary, and it must also remedy the violation.
Mr. Sutherland, I wonder if I can stop you there because I noticed that we have a question from Commissioner Graves. And I want to acknowledge that as you're moving between slides. Commissioner Graves, is your question related to the previous slide?
It
I
is.
wonder, Maria, if we can go back to the previous slide for just a moment. Thank you, Maria. Go ahead, Commissioner Graves.
Thanks very much. Brian, you may be getting to this, but what would an acceptable set of district lines for this map look like?
Well, that I can't say, and I will get to some more information about vote dilution and when. But I think I guess if I can say it this way, Section 2 of the Voting Rights Act prohibits vote dilution, and so it says a lot more about what can't be done than it does about what should be done. So the types of vote dilution here that I've indicated, can you hear me? It tells me my connection is unstable.
I can hear you.
Okay. The types of vote dilution I've indicated here, packing, stacking, and cracking, they are the no-nos in terms of redistricting. But there are different ways to draw district lines in a jurisdiction where a minority community is not, their voting strength is not diluted. So the touchstone is whether or not there exists a district that could be drawn in which the minority community could be a majority. And together with that fact, that voting is demonstrated to be racially polarized in the jurisdiction. And that racial polarization has resulted in the loss of minority preferred candidates. Where those facts exist, a district in which the minority community is a majority is the remedy for a violation of the Voting Rights Act. That is the right way to do it.
Thank you. So Commissioner Graves, I wonder if we can move on, and then at the end, we can spend some more time parsing this out. Thank you. Mr. Sutherland, please continue.
Sure, thank you. Okay, next slide. Okay. A few other important notes, and I mentioned this earlier too when I said that there's case law out there that has refined some of the elements of the Thornburg versus Jingles framework, and some of the important refinements are here. In Bartlett versus Strickland, the court said that a Jingles district only exists where you can draw a district in which minority voters constitute an effective majority of the voters in the new district. So crossover districts are not permissible, or they're not required by the Voting Rights Act. What a crossover district is a district in which minority voters may not constitute a numerical majority of the voters in a proposed district, but together with reliable crossover voting from the majority, they do constitute a majority. So for an example, in a hypothetical jurisdiction where there are 45% of the voters in a proposed district are African American, and voting is racially polarized between white voters and African American voters in this jurisdiction. But in the area where the African American voters are, there's a percentage of white voters that consistently vote along with the preferences of the black voters. So in this instance, while the black voters are not a numerical majority in this proposed district, together with reliable crossover voting, they hold 51, 53% of the voting strength in that proposed district. What the Supreme Court said in Bartlett is that that is not required that is not sufficient to demonstrate a Jingles district for purposes of Section 2. In other words, you cannot meet the first element of the Jingles preconditions without showing that minority voters are a numerical majority in the proposed district. Another important note on Jingles districts. It's been said many times that Section 2 of the Voting Rights Act does not establish a right to proportional representation. In other words, that minority voters in a jurisdiction, city, county, are not entitled to a number of seats on the governing body that is proportionate to their proportion of the electorate. That's just not what Section 2 says. That having been said, the Supreme Court has said that a relevant consideration in the totality of the circumstances is whether or not the number of districts in which the minority group is a majority is roughly proportional to its share of the population. So there's no guarantee under the law of proportional representation, but proportionality in that respect is a consideration, or can be a consideration in the totality of the circumstances. Next slide. Just another note, the Washington Voting Rights Act is new legislation that does something very similar, or addresses something very similar to Section 2 of the Federal Voting Rights Act, in that it prohibits vote dilution. However, it only applies to methods of election for a political subdivision, which is defined by the statute as not including the state. Next slide. Okay, the Senate report factors. I'm not going to go into a lot of depth on each of these, but I just wanted to share a little bit about these because they are part of the formula for proving vote dilution under the Voting Rights Act. So as I mentioned before, it's the Jingles preconditions which have to be shown. And after that, a plaintiff or group of plaintiffs will produce evidence of the Senate report factors. This will include the history of voting-related discrimination in the state or political subdivision, the actual extent of the polarization of voting. Some jurisdictions may have racial polarization at much deeper levels than others. The extent to which other features of the election system make it unusually hard for minority voters to get a candidate of choice elected. That could be unusually large election districts. It could be a majority vote requirement, as opposed to a plurality being sufficient if there are multiple candidates, and prohibitions against bullet voting. In many cases, there's also a slating process where different candidates run together for election to the governing body, where minority group members are excluded from the slating process. That is a factor supporting the vote dilution determination. And the extent to which minority group members bear the effects of discrimination in areas like education, employment, and health, which hinder their effective participation in the process. Racial appeals in political campaigns are another, and a lack of responsiveness on the part of elected officials to the needs of minority group members. That is also one of the Senate report factors tending to, or weighing in favor of and tending to support a claim of vote dilution. Next slide. So, considerations for redistricting. Proof of vote dilution. As I have been, hopefully have tried to convey to you guys, the vote dilution determination is a complex one. There is statistical evidence, redistricting data, demographic data, and historical data in terms of the Senate report factors, all of which is necessary to be organized and presented to a court in order to demonstrate vote dilution in violation of the act. And so it is, I guess, what I think is important is to understand the scope of evidence and inquiry that's required to determine that vote dilution is taking place or would take place under a particular redistricting plan. Demographic changes. Often changes in demographic makeup of certain legislative districts are one reason why the question of possible vote dilution arises. So, you know, places of interest may be places where the population has changed significantly since the last redistricting. And of course, avoiding racial gerrymanders. While redistricting should obviously avoid vote dilution to comply with the Voting Rights Act, it must not also it also must not utilize race as the predominant motivating factor in drawing districts. Although the preservation of crossover districts or avoiding other discrimination may be an appropriate reason for drawing districts in a certain way. Next slide. Okay. Any questions that you have, I would be happy to try to answer.
Hey, commissioners, I'd like to invite you to voice questions and comments, and please raise your hand and I will recognize you. Okay, let's begin with Commissioner April Sims.
Thank you. I'm a year in and I swear I still struggle finding the mute button. Thank you so much, Mr. Sutherland. I'm curious to hear your thoughts on the idea of coalition districts and whether there's a legal protection in a scenario where multiple minority populations might vote in a unified, racially polarized way in contrast to the majority population.
That is a great question. Thank you. So my understanding is that the law supports recognizing coalition districts as a Jingles district. That is a hypothetical district in which a coalition of minority voters who would not be a majority by themselves, but are a majority in the proposed district together, can satisfy the first Jingles precondition. So long as they, the data and the evidence demonstrates that they vote together, they have political cohesion, and that they are their candidates of choice or their preferred candidates are usually defeated in the absence of special circumstances by the preferences of the majority. My understanding, I talked to somebody just the other day who told me there was a new decision about this that I have yet to read. So I'm going to be checking up on that, especially now that you've raised it. But my understanding is that coalition districts do constitute Jingles district when they meet the other requirements of the case law.
Thank you.
Thank you.
Commissioner Sims, more? No. Okay. Commissioner Fain.
Thank you. And again, thank you for this presentation. This was extremely important for us to see before we go into our map drawing activities. I had a couple of questions, and of course, Commissioner Sims asked my first one. So my second question goes into the types of evidence that's used for that political cohesion test. And is there a magic percentage that needs to be reached? Is it, for instance, in this coalition example, is it you got a 50% plus one vote in a series of elections to show political cohesion, or I'm just wondering how that's been used in practice.
Also a very good question. So there's not a magic number in terms of what constitutes political cohesion or majority block voting. That is, I'm not aware of cases in which courts have said it must be this polarized or it's not polarized enough. Because it's a totality of the circumstances analysis. Whether or not vote dilution is taking place depends upon the polarization, the candidates who have run and lost, the circumstances of those elections, whether a district can be drawn in which the minority voters can constitute an effective majority, and other factors bearing on the history of discrimination in the jurisdiction and other things. And so that having been said, there is discussion in the case law about the relative strength of a racial polarization showing. So while I don't think there's a magic number, I do think there are some guideposts in terms of what constitutes, very strong racial polarization as opposed to simply strong racial polarization or weaker polarization. And I couldn't tell you more about that because I'm not a racial polarization statistician. Those folks would be better able to explain that relationship and when it's stronger versus not as strong.
I have a few more questions, but I'll let Commissioner Graves and others go and then come back to me if that's all right.
Yeah, Commissioner Graves.
Thanks again, and once again, thanks for that great presentation. I feel like I have a pretty good sense now for how we might violate the law. How can we actually comply with it?
Also a good question, and I think I would like to be able to tell you more, but I think I have to go back to what I mentioned before about how to draw the district in my hypothetical, my pictures there. I can tell you how to comply with the law is to not violate it. That's very circular, I know, but what I mean by that is that there are different ways that districts can be drawn in certain jurisdictions. There are many ways to achieve the goal of compliance. Districts could be drawn in numerous ways without causing prohibited vote dilution, and no one of those ways is required. Simply that the way that leads to vote dilution be not used.
Commissioner Graves.
Yeah, and maybe I don't mean to belabor the point too much, and we have other things to do, of course, but maybe it'd be helpful. I still don't understand how you could draw 5 lines on that map that would not involve some version of stacking, packing, or cracking. I don't mean to be a pest about it. I would just be interested to see what a compliant map in that hypothetical would look like.
Yeah, and I don't mean to be giving a poor answer that's not answering the question, but if I could, let me try it this way. In the picture that I provided there, it has a couple of different variations on the theme, but the minority community is located mainly in the center. Well, if the voting is racially polarized in a jurisdiction, and the minority community is voting for one candidate or a series of candidates, and the majority is voting for another series of candidates, and the minority community, it's such that if the minority community was 55% of the voters in any district, that the minority preferred candidate would be elected. So what is prohibited is to fail to do that, to fail to draw a district in which the minority community could constitute the majority. Now, could the lines could be drawn in a way to involve certain parts of the minority community? In other words, you might be able to draw 5 different maps that each had a 55% minority population in the jurisdiction, and they all look different, but in each one of them, they would be above that threshold, and given all the other circumstances of the cases and the evidence, you would say that district is, it avoids diluting the vote. So, like I said, I'm sorry if that's sort of obtuse too, but what I'm really trying to say is what the law says is don't let this happen, but how you avoid letting it happen and how you do it differently, there are different options, many ways of doing that, so long as it doesn't run afoul of this core principle.
Okay, thank you. Commissioner Fain.
Thanks, and thanks for, again, taking our questions. I'm sharing a lot of the same questions that my fellow commissioners have, and throughout the public testimony, we've heard a lot of calls from groups representing minority voters that are explicitly asking for packing. They're talking about keeping their communities together. They're speaking specifically about, tribal boundaries and where certain minority populations are live in higher densities, and talking about, this is where the map should be because this will put the most number of individuals from minority communities in the same district. Have we kind of moved more away from the lawsuits over packing, and it's more now about stacking, or is this? I'm trying to reconcile these two things because it almost feels like we're being asked to do specifically what the court is telling us not to do.
Well, I would say that packing, stacking, and cracking are really just kind of descriptions given to certain types of movement in district lines and how that affects minority voting strength under the circumstances. It's really just kind of a shorthand expression for that. What one person calls, there could be differences of opinion in a given jurisdiction over whether a redistricting plan is an attempt to comply with Section 2 of the Voting Rights Act, or is instead a racial gerrymander in violation of Miller versus Johnson. So I think, again, I think and I should also say, I hesitate to give you any specific recommendations for particular districts here in Washington State as you go about your business, because, I think, you could go deeper into it with the help of experts or consultants or counsel. But I just wanted to give these sort of kind of a broad understanding of what vote dilution is to be able to do that. But, I think like I said, what certain folks may think about a particular redistricting process or plan doesn't necessarily mean that considerations they raise wouldn't be appropriate for a body that's making redistricting decisions. I think, again, the ultimate touchstone is, does this plan avoid vote dilution? Could this plan be drawn better so that given the racial polarization in this jurisdiction, minority voters could be a majority in this district, and instead the plan that we have is not one of those, is not a plan where they are a majority. If that's the case, and the other facts and evidence line up that way that I've set forth, you may have a vote dilution problem. So it's, the goal is to see whether a minority community is being fragmented unnecessarily, whether they're being over concentrated somewhere, whether whether lines are changing such that more majority voters are coming into their vote in a new redistricting plan. But of course, alongside all of these other considerations and types of evidence.
Commissioner Fain, I see that your hand is still raised. Do you have additional questions?
Yes, just real briefly. I kind of going to ask the same question a little differently, which is, since intentionality seems to be a part of the tests in a number of different areas, and the intention of the lines to be drawn in a way that is racially that has a racial impact, would the evidence of public testimony from members of a particular racial minority expressing their desire for a particular type of map, would that evidence be something that would be used then as part of, if this were to be challenged, that evidence would be used to say, actually, trying to comply with the wishes of a particular minority group. I'm just trying to figure out how to, how we navigate these somewhat unclear standards to make sure that we're fully in compliance.
That's a good question, and I'm gonna not answer it, not because I don't want to, but because I need to. I want to take a look at some research. Actually, I think I don't know the answer, is what I'm trying to say, and I could find it for you.
Right. Well, on that question, and then if there is, emerging law on the issue of coalition voting, that I certainly would be interested in at a future meeting having you back to update us on anything that we didn't get to on this issue today. Very important stuff. Thank you.
Thank you, Commissioner Fain. And thank you, Mr. Sutherland, for taking the time to share with us tonight. We appreciate it. Let's now move on to our business portion of the agenda. All right, let's move on to item 4, which is the Executive Director update. And I'd like to invite our Executive Director, Lisa McLean, to provide some updates. Lisa?
Good evening, Commissioners. Happy summer. Just recognizing the summer solstice. So today I have for you a budget report. As of the end of May, the Commission has spent a total of $315,282 of its $1 million FY 2021 budget. And that includes $217,237 that was spent in May in order to pay for our website development, our mapping tool, staff salaries, office setup, and production of an animated video that you've all seen, and some of the transcription and interpreter services that we've now made a practice in our programs. So that's just the May part of it, because we'll have some more in June, and obviously we've had more meetings in June. So you can expect more of the transcription interpreter services coming out. So as part of that budget, and then maybe I'll stop, is you'll remember a couple of months ago, we have an issue with regard to the computer equipment and the pandemic affecting the ability to get the computer equipment in. I am happy to report, Commissioners, that we have all the computers that we ordered, everything that was, and all of the docking stations, everything that was ordered in February has arrived and will be billed in this fiscal year. So that's my budget report.
Thank you, Lisa. Do you have additional items for your Executive Director report?
Yes, I do. Sometimes I go through too much, so I wanted to stop and see if anybody had any comments on the budget, if they wanted to make any comments about that. Otherwise,
thank you. Comments, questions? Okay, seeing none. Lisa?
Okay, I just see smiles, and that's good, right? Okay, so on public outreach, I think you obviously, since you've all been involved in this, we've had 6 public outreach meetings. I think our last one was particularly good attendance. Even if some people hadn't meant to sign up for testimony, we still had great turnout. We've got 4 more meetings, including 2 tomorrow night before the end of the month. And we've also seen a lot more public comments coming through the website and not so much through the comment at redistricting.wa.gov website. We think a lot of this is actually sort of a more efficient use of our media advertising budget. I think we learned some things. I think I mentioned that at the last meeting, that we've learned some things, and we've been able to target it better. We see more engagement with the posts and more clicking through to the website from our posts. So we feel that we're using the money efficiently right now. We also, because of the success of our first animated video, that's still garnering success, we'll have another one very soon, which is on ways to engage. Another 2 minutes of just ways to engage. And we should very shortly, it's taken a long time, but we very shortly should have 9 translations of the first video available and up on the website and be able to send out to people. So that is what we're doing on public outreach so far. Any questions? Okay, moving on. The mapping tool, I'm happy to report. First off, I think I will apologize for the confusion I may have created last time. It is a topic in which I am not an expert. and I talk to people and I understand entirely what they're saying. And then I'm asked some tough questions by another audience and I'm like, oh, I guess I didn't really fully understand it. So I think one of the problems with the mapping tool is we weren't seeing the final product. So we weren't seeing what it was capable of, okay? And so that was part of the thing that was creating a little bit of confusion. I'm happy to report that tonight, if you go to the website right now and you go to draw your WA, you will see a link to click on and to draw your community of interest. And this is just basically, you don't do it based on population or anything. You just say, my community is this part, and it's also actually the other, it crosses over the, let's say this part of the Puget Sound, and it also includes this western part of Puget Sound, if that's what you'd like to draw. If you'd like to, as we've heard in some of the cases, we've heard that people want to feel that a community of interest is actually sort of a sister city type of thing, that this city and this city go together. They can draw that map. So that's not based on anything. The second thing that's there is the ability to comment either on your congressional district, as it is right now, or on your legislative district. Okay. What we are on the verge of putting out is a mapping tool. Again, I hope to have a link of that today and give the okay for that and be able to launch it. The mapping tool, which we will use 2020 OFM estimates and 5-year 2019 ACS demographic data, and people will be able to map with that. Okay, we'll be able to draw their maps. They can draw a map of the whole state. They can draw a map of district. We're going to encourage people to use it to practice because we want people to know how to use it. So when the real data is there, that they can use that. And they can submit a map, but we're also going to, as they submit, we're hoping, again, I asked the mapping contractor to do this, is to have a pop-up come up and say, by clicking here, I understand that this is based on estimated data and I should come back and fix this, come back and do it again when I fix it, I hope, okay, when we're finished, when the real data comes in. So in that way, people can start looking at some data right now, start thinking about things, and sketching out some plans right now. And that, I should have seen the sample, I should have been able to test, and we should have been able to test that today. I wrote to the mapping contractor today, said, where is that? We hope to be able to test it very quickly and to have that. And again, if you look at the website, you'll see it's a coming soon mapping tool there. So that's where we are on the mapping tool. And the good news about me and my confusion is that our GIS analyst is on board. He's getting up to speed very quickly. His name's Justin Bennett, comes as a graduate TA out of the Evergreen State College's GIS program. Also worked for the Olympia Parks Service on some mapping of some parks in Olympia. And he's an Air Force veteran. So we're happy to have him on board, and tomorrow he celebrates his 1-week anniversary, and he's already done a lot of great things in terms of helping all of us, staff and everybody, understand what the tools are, how they interface with the tools that the mapping tools that you all as commissioners are using. So we really feel like our own understanding has grown in the last week. So we appreciate that he's on staff. So do we have any questions there? Commissioner Graves?
Yeah, thanks very much. I see I'm poking around on there, like useful ways right now for people to comment on what they like and dislike about their current map, and to draw and to at least comment on their community of interest. Do we have a estimated time for when the map drawing thing with the estimated data is going to be ready to go?
I feel like I say I thought it was going to be the 1st of June. So I really, really think that we're like moments away. They had to do some jiggering to it on Friday, and they were doing some testing over the weekend, and I was supposed to get the link today. I didn't get it. So I would say by the end of the week, hopefully.
Great. As soon as that's live, I bet you all of us want to see it so we can go and tell everybody to start drawing some maps.
And I also think that we want to use some press to get it out and then make sure that people know that it exists and to basically maybe use some of our social media budget to push that out to draw people to it. I've gotten some calls from people saying, where is it? And we've gotten some emails from people and we really, I keep promising new dates. So Commissioner Fain.
I just want to say, I know that as you're figuring out the technology and types of data we should be and can use and this and that, I know that we had quite a discussion last time, and I just wanted to say I appreciate you taking time to go back and look at those things and try to figure out a way for it to work with current data. I know that was a lot of extra steps and things, but it's appreciated certainly by me, and I think by the other commissioners as well. So thank you.
Welcome. Okay, so just to conclude, the chair and I we made a presentation to the Washington State Association of Auditors Elections Conference at the invitation of Secretary of State's office. It was a great chance to make connections and to understand their concerns regarding our redistricting process and how it impacts their redistricting efforts. So we've already established the relationships, had some conversations going, we're going to plan for some meetings. I think that we're delayed. They're delayed. They're concerned about when they're going to get information. So we've been working the last 2 weeks a lot on looking at the historical record, looking at what we did in the past, how we can translate that into today's technologies and the like. So that's a good thing. And I think with that, my agenda is finished. Insofar as there are no questions.
Thank you, Lisa. Seeing none, let's move into the discussion portion of our agenda this evening. And so, commissioners, as always during our discussions, I'll call on you in an order I'll use throughout our meeting so that each of you can anticipate when it's your turn. And so I'll rotate for each discussion so that whoever speaks first will change in each discussion. So our order this evening is Commissioner Graves, Commissioner Faines, and Commissioner Sims. And so we have just one item for discussion this evening, and this is the purchase of CityKate Desktop Pro License 6. And so I hope we can discuss that just for a few moments. As you know, originally the commission bought 4 licenses for the CityKate Desktop Pro, and this is distinct from the public mapping tool. And so commission staff and the chair, myself, we request our own license. We feel we need those to be able to mitigate public mapping comments to the Commissioner's Desktop Pro as a tool for negotiation, and also as a tool for final technical adjustments. So this is to say, so that once the voting commissioners have designed your maps, we are going to be able to refine those together with partners as we need to do that. And keep in mind, as we work to create legislation, we'll want to do that at the end of the redistricting process. So that's the request in a nutshell. And so Lisa can tell us the cost of the CityKate Desktop Pro licenses, and then we'll begin with Commissioner Graves.
Yeah, the unit price is $4,250 plus a kind of package of support. So it comes up to $30,300. 6 licenses and 1 package of support just comes up to just over $30,300.
Great, thank you, Lisa. And so this is an action item this evening, so this is our chance to discuss it. Then we'll go to public comment, then we'll ask for action. So Commissioner Graves?
I don't have anything much to add on to it. It seems like it's a something that we need to do, and we have it in the budget, so it seems to make sense for me.
Great, thank you. Commissioner Fain?
Thanks. So who are the 6 licenses for?
So I think that question's to me, right? So we have right now the 2 commissioners have it, and myself and the GIS analyst have it, and we need to get 2 more for commissioners, 1 for the chair, and then we have 3 staff that are handling public outreach and public outreach organization. And then honestly, we're ordering one because of the fact that we think that things can get hairy at the end, and we don't want to be stuck with the fact that we might need one at the end and don't have one. So we're
And
rushing because I think there's going to be some rushing and pushing to try to get this turned into legislation.
And the 3 staff and that's what will they be doing on the
Communications and public outreach. And one of the things that we're trying to do is to try to figure out, and again, this is one of those things that we have to see the tool. We're getting, right now, we're waiting to get administrative privileges so that we can basically organize the comments for you all and get them translated to you, format as we're already doing that with regard to public comment. We're doing that in an Excel format like professional districts, so you could see what type of, so you can feel the volume, I guess, let's say. And we'll be doing that on the mapping tool as well. And I think that the capacity of that could exceed the GIS analysts. And so we would want to enlist the help of both our communications director, our public outreach coordinator, especially after the public comment period's finished, while we're waiting for the final data and stuff. And then also our social media associate.
Okay. Is there any map drawing that staff will be engaged in that is not at the direction of a specific commissioner or as part of translating the input from the public?
No.
Okay.
Not that I anticipate.
Yeah. Thanks.
Thank you, Commissioner Sims.
I think Commissioner Fain asked my questions.
Okay, great. Thank you. So if there are no additional questions or comments, I would like to move on to the public comment portion of our agenda. As usual, before public comment tonight, I would like to summarize what I've heard from the public since our last meeting on June 7th. Since our last meeting, the Commission has seen a growth in public engagement on social media and written comment relative to the short period of time that has elapsed. The Commission held one public outreach meeting covering Congressional District 3 and all legislative districts contained within it. At the third Congressional District outreach meeting, we heard from 29 residents, and additionally, we have received 44 comments either through our website or at our email address. Several of the messages were what I would call process issues related to our meetings. There was frustration from some individuals at the Commission for not appearing on camera during the third Congressional District outreach meeting. There were a few messages about issues connecting to video or audio. Commission staff monitor the comment box during the meeting and try to the extent possible to help out as quickly as possible. We strengthened our language to make clear the different processes used to sign up to testify as opposed to simply follow the proceedings. In the meeting for the third Congressional District, there were still a couple of instances of people unaware that they had signed up to testify, but the frequency has decreased significantly. Another process issue is about, we received limited public commentary related to public appeals to the Commission to act independently. There were calls to avoid any political consideration. Appeals asked commissioners to take calls to avoid, to take seriously the directive that maps be drawn so as not to purposefully favor or discriminate against any political party or group or to protect incumbents. There was also a single comment arguing in favor of considering incumbents during the process. A significant amount of the comments related to the process of drawing district boundaries and the way the process often results in the division of communities of interest across congressional districts or legislative districts. There were 3 areas of major comment. Number 1, frustration with Clark County legislative districts being difficult to traverse and dividing the cities of Camas, Vancouver, Battleground, and Washougal across legislative districts. The districts in question are numbers 49, 17, and 18. Number 2, frustration with Skamania County and East Clark County being in the 14th legislative district. These comments highlighted the connection between Skamania County and Clark County and decried the 3 hours of driving between the residents and the 14th Legislative District's population center. Number 3, the desire for Clark County legislative districts 49, 17, and 18 to be electorally competitive for Democrats or Republicans, depending on the district. There were multiple comments on 2 other subjects. First, there was continued desire to unite the Yakima tribal nation into a single legislative district. Second, there was a push to keep rural Thurston County in the 3rd congressional district. We received limited comments on congressional districts 1 and 2 regarding keeping their lines largely intact, except for shifting a neighborhood from the 8th to the 1st congressional district. Lastly, there were a few comments to either start from scratch on the congressional district boundaries or constitutionally change the number of legislative districts. This short summary of all the comments we received by no means does justice to what the commissioners have read and heard. Recordings of the public outreach meetings can be found on our website. We invite you all to follow these meetings at your convenience. And we invite your comments throughout this process as we try to stitch together a puzzle that best cuts the state into 10 congressional and 49 legislative districts. I would now like to move into the period for public comment. You are always welcome to sign up for the public comment period. We cut off registration by noon on commission business meetings and 24 hours prior to each regional meeting. We have, I believe, 5 participants who have registered to make public comment this evening. So we will assign each speaker 2 minutes. And tonight our web tech, Sean Murray, will facilitate. Sean will call your name, at which time your status in Zoom will change from observer to panelist. When Sean calls your name, you will have 2 minutes to speak. A countdown clock will appear on your screen. At the end of your allotted time, you will be muted. We realize that 2 minutes is a very brief time in which to share your comments. We're interested in what you have to say and urge you to send your written comments to us via the following email, comment@redistricting.wa.gov. And I think Commissioner Fain, you had your hand raised if you'd like to.
I appreciate you calling me. I wanted to ask, there was a question that I actually still had for the Attorney General's, Deputy Attorney General. And you reminded me of it because of the comments about incumbency and, ignoring where incumbents live. And I noticed on one of his slides, there was reference that the incumbents it was a factor that was considered when determining discriminatory gerrymandering. And I wanted him to expand on that, and maybe he could do that over email if you're able to pass along that question for me.
Thank you. So I will just ask Lisa to please make a note of that. I think we have more to discuss with the Attorney General's office in regard to tonight's topic. And so thank you, Commissioner Fain, I appreciate that. And we will be in touch. I know we'll continue conversation about this important topic. All right. So with that, Sean, I wonder if you would please call the first speaker.
Absolutely, Chair. We had 5 individuals sign up for tonight's meeting. We have 2 in the meeting itself. We have Jeffrey Olsen and Toller Bryan. We will begin with Toller Bryan. If you can unmute and turn your video on, begin your testimony.
Welcome.
Okay, thank you very much. I've got 3 questions. I hope I won't even take 2 minutes to ask the questions, but answering the questions may take longer than the 2 minutes. My first question is, I sent an email to the comments back on June 8th, and I was just wondering if the commissioners have seen that email and have any comments about it. That's question number 1. Question number 2, I've looked at the website briefly, and I've looked at this map, and I'm not sure I quite understand where the precincts come in. I'm looking primarily at Spokane County and District 9, and I'm looking at it right now, and it shows precinct 9020, 9014. Those aren't precincts that exist as far as I'm aware. And then secondly, or thirdly, what kind of data is the commission using right now, considering the fact that census data is not out, it's preliminary data, either what from the Office of Personnel Management or whatever, and how can we get our hands on that information?
Okay, thank you. And so I'm going to ask if commissioners would like to respond to these questions. Beginning with number 3, what data the commission is using. I'm happy to respond to that, but I wonder if one of the voting commissioners would like to respond. Commissioner Sims?
Yeah, I think we're still waiting for the actual data right now. I personally, and I think all of us, and I'd invite the other commissioners to weigh in here. We're in the data gathering phase. We won't be able to actually draw our maps until we get the actual data. So we know that there are population estimates that are available, using that to, do some preliminary reviews of certain areas, but I am holding out for the actual data. I know the population estimates that we have are inaccurate. I just don't know exactly how inaccurate they are. So I'm holding off on making any assumptions or moving forward until I have the actual data.
Thank you, Commissioner Sims. Would others like to weigh in?
I would just say that, yes, we received your email, and it's a very hyper-specific request. And I will say that I have not had a chance to look at those precincts in question, but I also received the comment by Senator Schessler saying that he would be happy to keep those precincts. So we'll take all of the comments into consideration. Thank you for sharing.
Okay, and Mr. Bryan, I would like to respond to question 3 as well, and say that we are not in the process yet of drawing maps, sir, because we don't have the official census data. We hope that by the end of this week, we'll be able to provide to the public, including yourself, a mapping tool that will be using OFM, Office of Financial Management estimates, as well as estimates, the 5-year demographic estimates. And what's that from again, Lisa?
The ACS, American Community Survey,
Yes.
5-year estimates.
ACS 5-year estimates. So that we hope will be available using our mapping tool by the end of the week. And regarding question number 2, which is responding to precincts on the website map, what we'll do, staff will take a look into that, and then we'll try and get back to you. I don't know offhand. It will take some research to look at whether and how we have accurately or inaccurately recorded.
Yeah, I would assume that the information that's on the website on the maps is well, number one, I know it's incorrect, but I don't know if it's supposed to be based on current precincts, 2000 or what year they might be, but those are not precincts that currently exist.
Thank you. So we'll be sure to inform staff and update that. Thank you for drawing our attention to that.
Okay.
Right. Terrific. Thank you. And Sean, if you would please call our next speaker.
Absolutely, Chair. Our last speaker is Jeffrey Olsen. If you can begin your testimony.
Welcome, Mr. Olsen.
Thanks for having me. I have a couple comments. I have to go back to my old college days, and I recommend that the redistricting use vector analysis. That will show which direction you need to focus on in balancing out the population. As for it stands, by the way, the clock hasn't started on mine. In order for the Yakima to become one congressional district, the current demands of the 4th and 5th will not allow it. And the North-South division would only give Okanagan and Douglas County to the 5th. It will not give the other 2 that are in the 8th district. In order to get Yakima into a single congressional district. The third is going to have to come over. The seventh is going to have to move heavily into the sixth, forcing it down the coast. And in other words, Clark County and Yakima is going to have to unite. That's the only way you can get there from here. Now, to get the other two eastern counties into the fifth, they have to take it from the 8th congressional district, and their population of that is about 130,000. And I don't see how the 4th and the 5th can accommodate that. It's going to mean major shifts, and I'm opposed to major shifts in lines. The simplest shift is best, in my opinion, the best shift. And that's the end of my comments.
Thank you. We sure appreciate your comments. Do the commissioners have questions or comments for the people on the panel? All right, terrific.
And I'm from Spokane also.
Great, we got it. We know who you are, Mr. Olsen. Thank you. All right, well, I'd like to excuse the panelists. Thanks very much for spending this time with us this evening. We appreciate you taking the time to be here and share your thoughts with us and recommendations and what you've observed. We appreciate it. All right, so let's move on to our next agenda item, which is action. So we have one item for action this evening, which is the purchase of Citygate Desktop Pro licenses. Before we move on, are there additional questions or comments about this action item? Commissioner Sands?
I move that we approve the purchase of these additional licenses.
Second.
Thank you. All in favor?
Aye.
Aye.
Okay, I see none opposed, so the motion passes. Thank you. And with that, I would like to voice special thanks to Brian Sutherland for sharing with us tonight. I would also like to thank you, commissioners, for your service, your time, and your attention. I recognize that it takes a lot of commitment and dedication to be part of this important work. I want to voice my thanks to you, Commissioner Fain, Commissioner Sims, Commissioner Graves. Thank you for being here. I would also like to thank members of the public who've taken the time to join us, those who testified and those who've just observed. Thank you for being here, being part of this important democratic process. Thank you to the staff who helped prepare the commission for this meeting: Lisa McLean, Jamie Nixon, Paul Campos, Osta Davis, Anton Gross, and Ali O'Neill provided staff support for discussion and action items. Tom Jensen provided information about the Citygate licenses. Sean Murray provided tech support. Maria Garza provided admin support, including taking minutes. And thank you to Lisa and Becky from Legislative Support for your continued help and support. This meeting is now adjourned. Have a good evening, everyone.